Okay. In that case, we'll call the meeting to order. It says 3:01 on Mickey on the wall. Do we have minutes?
Possibly, but as you can see, Helen is out. She's out for anywhere from 4 to 6 weeks. So,
Is she all right?
yeah, she had some surgery on her knee, so she's recovering. So she'll be taking the minutes. She's going to watch these meetings and take minutes from them and then email them, but I don't have minutes from your last meeting.
Okay. Okay, then I guess we go into old business. And you got Antelope Run as the first item, so.
I do, and this was at the request of the developer and the developer's representative to put it back on the planning board agenda because they have some proposed plans for the conditions, or some proposed thoughts, I guess I should say, for the conditions. So if you don't mind, I'll turn it over to Bernadette to explain that to the board.
Hello.
Ew.
Now I do have a note from Mr. Griffin, and in order to put this back on the board, since it expired the end of March and to give it time to go to the commission, Jim granted a extension on the time limit. So here's just, the front page is Jim's offer to mitigate KOA Road.
Thank you.
Improvements needed. And then the other pages are just my email to Nicole for granting the extension. I forwarded Jim's grant a 20-day extension, and then I put a letter on the back page. So just so that you know gave the extension. Now, and I feel not very smart about this. I guess Jim's been in contact with Josh, with the county's road supervisor. I've not been privy to any of those conversations, so I'm kind of in the dark too on that. I did just talk to Jim a little while ago, and before I came up here, and he said yes, he had been communicating with Josh. Nicole was hopeful maybe Josh or someone would come.
He won't be here, but I do have some information.
Oh, okay.
Because I'm on the phone about 20 minutes ago.
Yeah, same. So, and Jim said he is available on the phone if we need to call him to answer any other questions. But basically, it's Jim has a gravel pit on his property, and he wanted to offer the gravel for the county to upgrade that road. He talked to Jack Road Armel about what needed to be done, and then again, I guess he's been talking to Josh. So I do not know what those two have agreed with, but this was to mitigate the condition of approval to upgrade KOA Road or pay a proportionate share. Because Jim thought it would be better to have some improvements than to just put money into an account that probably wouldn't, do a whole lot. So that because like he said, he wants the road to be good too, to the subdivision. So I don't know if there's any other questions, or I'll turn it back to Nicole to give us Josh's information.
Certainly. So I did speak with Public Works Director Josh Obert. I'll turn this towards me. Can you hear me here? I'm not picking on you. I just know typically I talk to you.
Barely, but you just have to yell through the mask, that's all.
So I did speak with Public Works Director Josh Obert just a little bit ago. Him and our county road foreman, TJ Gravely, went out and looked at the material in the pit. They looked at KOA Road, at the condition of KOA Road. Josh stated that this pit is not a DEQ approved or permitted pit, the pit located on Mr. Griffin's property. So in order for the county to use the material, it has to be a DEQ approved and permitted pit. Also, he said there's no binder in the material, so it's not an approved mix design. And then lastly, he said it would be cost prohibitive for the county to do the improvements to KOA Road, because there is a significant amount of improvements that need to be done.
If there's so many to them, the county, how can we put it on the client? The price?
To improve the road?
I agree.
Yes. If the county can't afford it, how come we can make him afford it?
Because he's developing a subdivision.
That's his choice.
That's what?
That's his choice.
Yeah, it's his
You know,
choice,
you have to take a look at the subdivision, say, is it worth the money or not? And then, whereas the county's position, the taxpayer base, you don't have that choice. That's the way I see it.
Again, I'd like to point out the road requirements on this is not a provision in the regulations currently, I believe.
Well, I've got a different take on it, because if I'm reading this right, the reason for bringing it back to us is you expect us to do something with it. And I don't see that there's any legal basis for the planning board to even necessarily weigh in, other than to say, okay, we accept your offer, not as in terms of accepting it, but there's nothing in MCA, everything says governing body in terms of regards to mitigation. To me, we don't even get to weigh in on it, it's just, this can be presented to the commissioners, and it's their final decision anyway, but there's no place that I've been able to find that says that mitigation, says the governing body can cause mitigation to happen, but it doesn't say anything about the planning board.
Right. Well, I know Nicole and I discussed it, and because I didn't know what the protocol would be to go directly to the commission or to come back to the planning board. And like she said, well, if it's new information, we could start at the planning board and then go.
I don't have a problem
Just so everyone
with
has-
starting, I just see it, personally, I see it as being a slippery slope if we come back and weigh in on something after we've already made a recommendation to the commission, and it was scheduled, and I understand his desire, and if they can work out the details on it, it might work. I just don't see that it is appropriate for the planning board to take a position on something that is really the governing body, the commission's decision to make. We can't do anything with mitigation.
Well, the reason it is coming back here, because this is a planning board recommendation. So I know that it was Mr. Griffin's hope that we could amend, I'm not a planning board member, I'm sorry, that the planning board could amend that condition of approval for paying a proportionate share. So that's why it's back here, for recommendation and discussion. That doesn't mean that they still can't go forward to the commissioners and request that the commissioners amend that condition, but that's why the extension and coming back to the planning board.
Yeah, but that's what I was just talking about. It's not so much whether any of us like or dislike his mitigation offer. I just don't feel like it's appropriate and or legal for the planning board to say, essentially, it's a do-over. If you don't like the results you get the first time, come back 2 weeks, 2 months, or whatever. And I just see that as a really dangerous precedent, when all it really takes in this instance is to take this exact same offer into the scheduled meeting with the commission and say, okay, we've had time to think about it, here's an offer that's on the table. It doesn't appear that he's being unreasonable about it. I saw somewhere in there, he said the offer's still good You know,
Yeah,
if they choose to do it at a later point or something of that nature, to me, that would say that that's the opportunity for him or somebody to see what would be involved in getting a state license pit. I don't know what he can do about the material. I just don't see it being appropriate for the planning board.
Is there no place in the regs, Nicole, I can say I'm not familiar with, that if new material appears that, or is that, I know the commissioners have to have new material, but is there anything for the planning board that we can consider new material in our regs?
I
Or
was
the
actually looking at my
MCA.
regulations on my, online here because I failed to bring our existing regulations. Somehow I have proposed amendments, but not the existing. So in our current regulations, yes, there's a section, and I can't find it on here, but I know that there's a section on new information that would warrant a public hearing. I don't feel that this, first of all, there was no public hearing required for this development because it is a first minor subdivision. And this is new information, but I still think that we can keep moving forward. You know, we don't need to start back over with the beginning process. This is just a proposal to hopefully make an amendment, hopefully on behalf of the developer, to make an amendment to that condition of approval, that recommended condition of approval moving forward with the commissioners. It was my thought, you know, and in talking with Bernadette, that it would be better to have that discussion here at the planning board level before rolling on for a recommendation to the commissioners. So that the commissioners would know that the planning board also considered this information. I don't think that really answered your question very well, though, I feel like, so.
Well,
Yes,
I
it did.
think,
Okay.
and
I felt that was a really long
No,
explanation,
I
okay.
did answer it.
and moving forward, I mean, and not that it would affect this one at all, but it is awkward when you get the conditions of approval, you know, at the planning board with absolutely no time to look at what they would be so that you could, you know, develop evidence or, you know, bring evidence forward or to argue them without time. So I think moving forward, it would be great if, you know, somehow the conditions of approval were brought forward and the discussion ensued, but no decision was made, or there was time, you know, to go forward for the developer, especially when the developer is out of state, or even if they're in state and you can't be here at the meeting. Sometimes I don't have all the answers for the developers.
What would it take, but the roadman's not here yet, John,
Yeah, he will not be here.
he will not be
No, he
here.
will not be able
To
to
get an
attend.
idea what, Herb would know, here, I can go to Herb. What would it take? I know you haven't seen the dirt. What would it take, or what do you have to do? I can make a mud pie, but that's it. How would you improve that dirt to make it acceptable for the KOA road?
It would depend on soil samples, gradation, what's known as the PI. I'm not sure about the pit area. When I went and looked at the subdivision, I drove, that's where I turned around. I didn't get out and feel it, but I can guarantee you that stuff's slicker than snot when you're driving on it on the snow melt. So there's some fines in it. Whether or not there's any clay in it, that could be a detriment. It really depends on what it takes, what the soil samples would come up and what the specs would be. And then we'd have to take that and go back to our standards, which is the Montana Public Works for the gradation and that sort of thing to see what's there.
Now,
But
the
it-
next question is, if he pays what he's going to pay, if he goes ahead with it, and the money's put in the general fund, what happens, the road stays the same and nothing's done.
Well, that's part of the problem that we've had for a long time. I would suspect that the best outcome for the county would be if Mr. Griffin follows through with this, that he would stand by that, is to take just what I'm talking about is, first of all, find out, Josh Obert may know, TJ may know, but to get the permit to make sure that it's legal to use, check the gradations, because then you're dealing with fact as opposed to opinion. But it's the kind of thing that we don't have the power to order somebody to go out and get tests. The commission does. Or the commission can tell Josh to go get them. You know, that's part of the standards. If they sent him out to get them and they came back and they decided not to use, then it's their decision as to who's going to pay for the test. But we can't say, call up a lab and say, hey, go run gradations and a sieve analysis and a PI and everything else on all this material to see if it's going to meet spec. That's not something that we're empowered to do or is in the MCA. That's the only problem I have with it. I think that in the long run that it could prove out.
Well, I mean, that's pretty slim odds, isn't it? Because I thought that all that rock has to be crushed rock for road grade rock. Like I have a gravel pit on my place too, but they just can't take gravel out of there and use it for road base, and it's got to be crushed.
Well, it depends on the position and the fill. You can get by with pit run in the lower, you know, but I don't see that we need to get into worrying about our standards or even the Montana standards. It's not something that we can decide and or can do anything about, in my mind. I think it's a fair offer, but it needs more time and more fact. And it seems like he's got the right idea here, because if he can meet the standards for the fill out of that pit, and unless there's either too much clay or something of that nature, you can do that sort of thing by screening and or crushing. It just depends on what it takes. And we're not set up to make a decision on that.
Can we make a recommendation based upon this?
I don't think so. I mean, the only recommendation is say, you know, looks good at face value, take it under consideration, and because they're the ones that have to do all the things that we're talking about here. It's not a question of, in my mind, of an official action. We can say, yeah, this looks good at face value, but we need more facts, and then see what the commission wants to do with it, because it's not our position as a planning board to make those kind of decisions. We don't have the power to do it, even if we wanted to. I don't think. I can't find it. I did look to see what it said about bringing them back. You can have additional information, but again, that's from a public hearing. Doesn't say anything about coming back to.
Well, I know, I think other subdivisions have come back in the past and had conditions of approval amended. I know some of them, I think one of them was down south where the condition of approval was that they paved the road, and then they came back and went into phasing so that they didn't have to. I guess that wasn't really a condition of approval, but I can't think offhand, but it just seems to me that there have been.
And there's really no issue with it coming back to the planning board. You know, the developer has submitted I assume that's in this packet you gave. I didn't even look through it all, but the extension.
Yeah, the extension
Okay,
is
yeah,
the next few pages.
So the developer has provided the extension in the hopes for the planning board to take another look at it. If the planning board chooses to not amend your recommended conditions, you can do that. If you wish to amend your recommended conditions, you can do that too, because it hasn't gone before the commission. The only time that you would not be able to see it is if it's already been before the commission and they made a decision. So that's kind of the end-all date. So once the commissioners make their decision, you don't see the subdivision again.
That's right.
So the commissioners have not seen it. It hasn't been placed in front of them for their decision yet. So we're still in the recommending phase with the planning board. So it's not really anything that has to be outlined in the subdivision regulations or shown anywhere, and especially since it's at the request of the developer. The only time that we might be on a little bit of a thin ice would be if the developer did not submit a request for an extension and the developer was requesting it to be on the the commission agenda, but you were taking it back. But the fact that it's at the developer's request.
Like I say, I don't have a problem with the proposal, I just have a problem because I think we're setting a precedent. There is one other option. We can vote to delegate our authority to you to make that recommendation to the commission at the commission's office, in the commission's meeting. That's an MCA.
To make what recommendation? Just a
Well, it
recommendation?
the planning board may delegate to its staff its responsibility under subsection 1 to advise the governing body on any or all proposed minor subdivisions. So what I read into that was an option would be to have a motion to delegate you as the planning board's representative for this particular deal. You're the one that you're privy to Josh, TJ, you've got a lot more input than any of us do. To me, that's still, and additionally, you're a county employee, so that it's not like you have a volunteer board setting something up. That's the problem that I have, because I feel like we're powerless to do anything about it other than make a recommendation that we say, here, Nicole, you take this to the commission.
Yeah, you absolutely could do that. And typically that MCA is used when we're up against a deadline and the planning board is unable to have a quorum meet so that the developer or the landowner isn't held up by the lack of a quorum.
Well, it doesn't even say for the lack of quorum. I'm not holding myself out to be an attorney. That's just the last paragraph in the role of a planning board in relation to subdivision and plats. Because what I was looking for was to see if we had authority to do something like that. And I don't see that we do anywhere because everything says governing body. Even in that one, it says that we may delegate to its staff, i.e. you, its responsibility under subsection 1, which is the normal provision, to advise the governing body.
But isn't that what all the conditions of approval are? I mean, you guys don't have the power to enforce any of them. They're your recommendation to the commission.
Well, right, and they don't have to take them.
Right.
And they don't always take them. But what I'm getting at here is, to me, that is a more correct procedure than the planning board changing a recommendation or making an additional recommendation on added information, because I don't see that that's within our realm of possibility. Like I say, I have no problem with this. It needs facts. I think it's a good deal. I just don't think it's appropriate for the planning board to take action on it.
So we certainly could take really you might have two options here, but the most logical would be to take the findings of fact in order based off of the staff report that you received and the conditions you put in place and take it to the commissioners. And then Bernadette can still present this information to the commissioners similar to what she's doing now, because the decision hasn't been made to make that a condition of approval. It's simply a recommendation, your recommendation. Previously. those are options too. It seemed to make sense to bring it back before this board so we could have this discussion.
Okay, well, we've had the discussion. You and I are doing most of the talking, but the idea, my whole idea being is if you don't have a problem with it, then I would suggest that we do something to delegate this specific one to you as a representative because of the fact that I don't think that it's within the realm. We can tell you, okay, it's your bailiwick now. But that's not, you're not acting as the planning board. I just don't feel like the planning board has the legal authority to make that recommendation. If you make it as an advisor already in your position to the county, that's one thing. I just don't want to see us set a precedent for do-overs.
I don't think we're setting a precedent. We're looking at new information and trying to make a decision according to that new information, whether we do it or don't. And this might be the first one that this comes up on, it might not be the last one. But we're not setting a precedent. We are actually supposed to look at new information, and this is new information.
Well, I don't disagree that it's new information, Jenny, but what my whole point of it is, and again, we have this in writing from the subdivider. We don't have Josh Obert's in writing, but what he's telling Nicole is that they can't use this material. So how can we make a recommendation on something that at least verbally we suspect is inappropriate fill?
We would add to that, say, we could use, if Josh says it's appropriate to amend the soil to use as a road, they gotta do something to put down for a road no matter what. And the other thing that, the way I'm looking at it is, and this is what precipitated all of this on the new subdivision regs, is roads. We say they have to do roads, they donate the money, it goes in the general fund, and then it's forgotten for years. So it doesn't do anybody any good. So the road's still rotten.
Well, it's not like I agree with you in principle and practicality, but the law says that the money can't sit there forever because there's a 20-year sunset in MCA on all of that.
And then what do they do with it? Like the
They have to
the
give
money
it back
from
to
the
the,
silos.
where it came from.
They give it back to the developer?
That's the way I read MCA, is it's no different than a road maintenance agreement or any of these other things. There is a 20-year sunset clause on essentially everything that is required by the commission and or developer. If it takes more than 20 years for a build out, then by law, whatever is not used out of that account should be returned to the firm, individual, whatever, that paid the fee.
Bernadette, did the developer know of the problem with the soil from Josh?
I don't know, I haven't been privy with any of the conversations between Josh
Do you
and
know,
him.
Jeanette? Do you
I don't
know?
I don't know if
That's what's hard
they
when,
spoke with him or not.
yeah, they've been having their own conversation that I didn't even know was occurring. And I don't think Nicole did either until she talked to Josh.
Yeah, I only knew this just, like I said, 30 minutes before the meeting.
So neither one of us knew they were talking. So,
Oh, I agree. Like I told you a long time ago, I don't have a problem with this. I just have a problem with the legality of it and setting a precedent. But I think this needs to be taken, in my personal opinion, needs to be taken to the commission. The commission can say, okay, they can tell Josh to get the tests, they can go do the tests or whatever. you can talk to your subdivider and he can see what it would take. He may want to withdraw the offer if he finds out that it's too expensive on his end to remediate the pit and or to get the work, to get it certified by DEQ. I think it's more a timeliness issue in my own mind than a dollars and cents. But it could, depending on how the tests come out, it could wind up not being to his advantage. I just don't see that we're in a position to make that kind of a decision or even a recommendation on it.
Well, I
Suppose,
still argue that the recommendation for him to upgrade the proportionate share of the county road is still setting a precedent and going beyond the reach of the regulation.
We've done that for years. The
Not
one,
county roads, only subdivision roads.
I agree.
Wheatland Road.
Does it say
Price
in it-
Road. They
What
had to
was-
pave Wheatland Road, that's a county road.
Yeah, that was before the lawsuits though, right?
I don't know, are you talking about the Hamlin
Yeah.
case out of Lewis and Clark? I don't think so.
I
Because I
think
thought
there
we
have been
had it-
other cases. I just don't
Yeah.
think it's the right thing to do, that's all. It's not, I'm not saying this isn't the right thing to do, but his offer needs to be refined, and we can't refine it.
can we
Only
give
the
him an
commission can refine it.
option? We should be able to at least, may we give him an option to come up with a change to add to it or subtract to it or whatever he needs to do, instead of us just passing it on?
Does it say in the regulations that you have to improve county roads?
It doesn't say you have to improve county roads, but it's under design and improvement standards. And I have an email, and I know I've shared this with you previously, from our Mako land use attorney. I'm not going to read the whole thing because it's very long. But it says the developer must pay the proportionate share the subdivision will have on the roads leading to the subdivision. If the access road is an undeveloped county road, since no one else is using the road, the developer, will have to pay for 100% of the required improvement to the county road. That's not the case here, because this is a used county road. There's one other residence approximate to Mr. Griffin's property that's using it.
So if it's a Mako law,
It's a Mako land use attorney recommendation.
Recommendation,
That
it's
she-
not law. I'm gonna use Ray Creek. We lived up Ray Creek, we had shingles next to us. Suppose shingles subdivided. Does that mean they have to improve the whole Ray Creek Road?
Their proportionate share of improvements.
And if they're the only ones on the road, then
it's
they
a
have to build the whole
recommendation.
road.
It's a legal opinion.
By one lawyer.
Well, the one lawyer that advises all counties in Montana.
Well, I don't know if this was, I was going to give this to you later before I left, when, after you decided this, but when you were discussing road issues, just some of my input, since I couldn't stay probably for the whole meeting. So I had just wrote some notes, a list of things just to think about from my end that I wanted to inject. But two of the things that I'll throw in right here, one of them was the Christensen lawsuit that we've talked about before, that a 12-lot subdivision was ordered $2 million to pave the road. The judge threw it out and said, no way is one subdivision responsible for fixing a road. And I'll quote the judge. It said, to require the developer of a 12-lot subdivision to pay in excess of $2 million to pave an already deficient county road is a shift the government's obligation onto private parties. This was Judge Sherlock. The judge then sent the subdivision back to the commission for reconsideration. In the meantime, the county had passed new rules regarding subdivision road requirements. This was Lewis and Clark, which said developers had to pay a proportionate share of the improvements needed for the roads leading to and from their subdivision depending on how much traffic the development added to the roads. The commission applied those to Christensen's proposal, but Judge Sherlock ruled last year that since the county had no plans to upgrade the road at this time, no time frame to do so, and no dedicated account in which to hold Christensen's money, that was again illegal. So even though they used the proportionate share, if the county didn't have the plans of upgrading it, we do have accounts dedicated, set aside, but I don't know if the other two matter. Like I said, and on my thing I said, I am not a lawyer, so this may need to be clarified from Mako or our county attorney, which is great now that we have a deputy. That'll help us. The other lawsuit, the Hamlin one, the judge stated that while the district courts noted in Hamlin's decision that the county was within its rights to require a developer to pay a reasonable fee to address impacts caused by a subdivision, what is not appropriate, however, is for the county to require the developer to pay not only for the impacts of his subdivision, but to also address a pre-existing deficient road, which is the county's responsibility. So those were just some ideas I wanted to throw out when you guys come up with proportions that, you know, maybe get clarification on this. Because I can understand, and I think the Yellowstone one talks about maintaining level of service on proportionate share. So I just think it would be really important for maybe our new deputy attorney to look into it, to see if you can pay for the deficits or if you're just supposed to get proportionate share for your added impact. I think there is a lot to find out about that. And then it went in on impact fees, which we don't have.
Isn't the fire an impact fee?
We don't call it an impact fee. We call it a cash in lieu of water supply fee.
Yeah, we have to have that illegal to call it impact fee.
But according to MCA 76-16015A, impact fee means to charge a charge imposed upon developments by a government entity as part of a development approval process to fund the additional services capacity required from a development which is collected. The term does not include on-site or off-site improvements necessary for new development to meet the safety, level of service, or other minimum development standards that have been adopted by the government entity. So in my opinion, there's a lot of questions, legality on county roads and the proportionate share of what I know in the past on subdivision roads, we've looked at them, what does it, to get an estimate of what it takes to get it from the current standard to the subdivision standards, which may be new base, new rock, new, you know, and they've paid a proportionate share of that. But if they're county roads and if it's maintaining level of service, you know, I don't know if we could use the formula of, okay, to improve it to county standards if it's not there. Because that, to me, that would come into the definition of it being deficit already, if that makes sense. But anyways, I wrote these out for you guys just when you're going through the new road standards of just ideas to maybe incorporate or not incorporate. And I copied them. And I could not find the actual lawsuit cases. I just got the newspaper articles and they had the judge quoted. So maybe the lawyers would have an opportunity to pull the actual case.
Thank you. Thank you.
You're even highlighted goodies.
I just so you didn't have to read the whole thing. They didn't want to. Just quickly.
Okay, so what's your pleasure? This will come in handy later, without a
Right.
doubt. But as a question to the planning board, I've
Well, I
already
plan on
spoken more
using-
than I should in terms of how I felt about it. What do you want to do? I feel the only appropriate thing to do is to delegate the authority. You can call that running and hiding, but I don't feel right about setting a precedent somewhere in the future, because it's kind of, to draw an analogy, it's a 1921 deal that made KOA a county road. They didn't envision this happening then. We don't envision what can happen from a precedent that we set today, maybe 40 years down the road. I just don't think I don't think we have enough facts.
Since we don't have enough facts, how do you all feel about sending this back to him and letting him work on it with the county road people? I don't want to turn him down or turn him
I don't want to
over.
turn him down, but I certainly don't want to tell him he can either.
We're not telling him he can, we're telling him to
Would,
add to it.
Well,
would we have to stipulate what we expected though on these additions? I mean, if we sent this back to him to add to it, are we going to tell him what we feel he should add to it?
No, we're telling him to look into it if he wants, to adjust it, to make it better, or drop it
well,
and go with the county.
Okay,
Do
that-
one or the other.
that's an interesting thought, and I guess what I would propose as a solution along those lines, Jenny, would be that we would perhaps take a vote to table it with a suggestion that it be returned to the subdivider for his further action.
I like that a lot. Bernadette, what do you think about that?
I can ask him. Like I said, it's, we could either call him or I could just let him know, but without being privy to other conversation, I don't know how to answer.
Well, and I don't think it's fair to try to call
No,
him
and
to
it's
put him
not.
on the spot either, but it's a solution that I personally would feel comfortable with, because we're not taking a position, like I say, it's not a bad offer. It's just that we don't have the appropriate authority and/or information to make those kind of decisions.
I
But
don't
we
have-
could table it and return it to him, and then it's his decision. He
Exactly.
either wants to continue it and go on with another extension or something of that nature, or the old thing, if time is money and he thinks he's got 3 of the 5 lots sold, he's damned
Did
the
you know
torpedo's
the-
full speed ahead.
I just found, when I called him right before this meeting, he's gonna be here between the 3rd and the 10th. So, maybe if the planning board met, he could be here or have time to meet with Josh in person to discuss it and come up with a plan.
What do you think about it, Mary and Dennis?
Yeah, I think that gives him an opportunity to do,
Right, we're not
to
cutting them off.
rectify what,
No, I'm not trying to cut him off, I just don't think we
No.
can say go ahead.
At a planning board meeting, maybe he'd have time to meet with Josh
We're-
and them two come
yeah,
up with a
we're not
plan.
making a decision that way.
So April 21st is essentially the new deadline. And I went on 20 working days. I didn't go on 20 calendar days. Again,
That's
I'm
fine.
not sure what he was anticipating. So this board, you can simply say thank you for the information. You don't need to table it. The only issue I'd have with you tabling it is you would eventually have to meet to get it off the table. What if Mr. Griffin's preference is to say, no, I'm just going to go ahead to the commissioners and I'll have this discussion there. I'm going to meet with Josh and then we'll have this discussion with the commissioners. So if you table it, you have to remove it from the table at some point in time.
Yeah, that's a good
To where
point.
you can simply say,
Yeah.
thank you for the information. If he requests to be back on the planning board agenda, we can place him on the agenda. That was just a thought.
Okay, I like that better. I
Yeah.
was just looking
Yeah,
at a
like
way of not cutting him off, but not making a decision for the commission.
Yeah, I don't wanna make a decision on it.
I don't either. They wouldn't like mine.
Well, I
On a lot
don't-
of things.
I don't have the ability, I mean, I don't know what his dirt looks like.
Well,
And if I
there-
did look at it, I wouldn't know what I was looking at other than dirt.
Yeah, we're short of information. We couldn't
Yeah.
make an intelligent
Well, and I feel the
decision.
same way. Like I said, I feel ignorant about this. I don't know anything about gravel or him saying the top crush or to crush it and add road mix. That's all beyond me.
You wanna know the truth, I didn't.
Well,
know
you can make it out of
I know
just
there's
about
waste
anything,
that people
Bernadette.
on
It's
the
just
road
whether or
and
not
stuff,
it
but
is economically
what it is,
feasible.
I don't know.
Right.
Because you might have to wash it. There's any number of things that could add just tons and tons of money that would blow the thing out of the water. Okay, do you think we need any action other than what you just said? Say thank you for the information, and then it's up to Bernadette as the subdivider's representative to advise him, and he can take it from there.
Was that a question? That's the question, if that was a question, my answer is yes. That,
Good.
I mean, you certainly can add a condition, remove a condition, you can do any of those things, you can table it, but that would be my recommendation, just to say, okay, thank you for the information. Maybe we'll see it again, maybe we won't.
Well, you're our spokesman, you just said it.
Yeah, what you said.
And so it
Yeah,
doesn't
that
require
would,
a
that could
motion.
work.
Okay. I think it has potential, it just needs to be massaged. And a whole lot more information.
Yeah, it kind of compares, depends on what the pit's like. I mean, that's the
Mhm.
real key to this, is what kind of material's in his pit, and what the county's willing to accept, along with what they're required to accept. They don't have 100% leeway with this either, because
Yeah.
that
Well,
gravel
let's
has
just
to
throw
be
it back and
spread,
he can
so-
be advised, and then he can decide what he wants to do with it.
Yeah, yeah, he needs more information,
I have a
obviously.
question.
Yeah.
If Mako would say that sprinklers, underground sprinklers are recommended for every subdivision, would we require it?
We had
Even if it's not in our regulations?
it wasn't in our regulations. We had a consultant that tried to make fire sprinklers.
Well, I'm just going back to the roads, if.
Okay, well, but what, I'm using that as an example, Mary. The whole idea was, yeah, you can put it in there until somebody challenges it. You can put anything in there.
Mhm.
But my reason for being here is to try to keep my taxes from going up any more than I know they're going to anyway. And I certainly don't want to be party to putting something in there that's going to cause a lawsuit.
Understood, I'm just,
So you
Going
could
back
put
to
it
the road.
in there, it wouldn't, in my opinion, it wouldn't be very reasonable. But in this particular instance, it cost the county a lot of money because we had two consultants and they stirred the pot for 2 years. And they wanted, nobody's arguing that it's a good thought to have sprinklers in the houses. But then there was a court case that proved that it wasn't legal, and all of a sudden it went away, and we were left with 2 years of arguing, and Nicole and one board member went down and had, 2 meetings with Three Forks. She had the whole thing settled, and we've been good for 10+ years. I don't know if that answered your question, but that's,
I
But we
was
didn't
just-
end up with sprinklers either.
well, I'm just making the comparison to requiring the
I-
subdivisions to upgrade county roads. We wouldn't do that for the sprinklers, why are we doing this for the roads if it's not a law, just a recommendation, and it's not in the regs?
It depends on the interpretation of what's already in MCA.
Okay.
The short version, I don't know if it's the answer you're looking for. In my opinion, the only thing is it has to be an MCA. It just depends on who's interpreting it. Whether it's Mako or a judge or something else. That's just
Yeah,
the way
I
it is.
feel like a lot of this stuff, it doesn't matter, Richmond, whoever, county, Richmond. Some of the stuff they have in there for the roads is not necessary. And to me, it's waiting to be sued.
Well-
And not tested, like you said, hasn't been tested yet.
Yeah.
Where, we'll stick with this and then I'll come back.
In
later.
talking to Jerry, I'm under the impression, he didn't come right out and say it, but I was really disappointed because I hoped that Richland would have the, trying to think of the right term, proactive approach in terms of making things a business decision and letting somebody decide about it. Just making sure that the environment was, in the county was protected. What they chose to do, and what doesn't show up in here other than reference, is they are zoned to the teeth. You know, you've got a zoning ordinance that you have to meet to even be able to file a subdivision, I'm under the impression. I haven't seen the paperwork, but that's the way it reads. That, you know, that's just layer upon layer, and that's one reason that Richland doesn't fit here.
Here.
Most of what I told Jerry, I met with him last week to give him everything that we had done so far, so he could start rewriting them, and it said Broadwater County, and we could actually had something to review. But all I told him, I said, we haven't done anything with roads, but I said, if you get that far and you want to write something, just strike Richlands and put in Broadwater County standards.
Very good.
At least for the first blush, until after we've decided in terms of what's going through there.
Because we've been working with Broadwater since.
That's exactly right.
2012.
If it ain't broke, don't fix it.
Don't
There's-
fix it, yep.
I can see maybe 2 or 3 paragraphs out of the Richland road specs that would warrant consideration, given specific instances. But I certainly wouldn't want to adopt them. There's a lot of things about theirs that I don't like, and I think they're actually in error in some places. From what I've seen, their own standards don't match what they're saying in the written word versus what they require.
So we should get on to the roads. First we'll get this out of the way. and then
I'm
get right
all
on to the
for
roads.
that.
I am all for that as well.
I'm ready to rock and roll.
So I just want to point out some portions of MCA here. So this is 76.3.5014. And if you have your blue book, it's on page 104.
You can just leave it there and don't slide.
I hope so.
So this says, the governing body of every county, city, and town hall shall adopt and provide for the enforcement and administration of subdivision regulations reasonably providing for, and number 4 says the improvement of roads. Granted, that does not say county roads, that does not say subdivision roads. So I'm not going to make a legal interpretation of that, but it does say the regulations shall provide for the improvement of roads. And then on page 108, it talks about the payment for extension of capital facilities. And this is 76.3.510, item number 1.
What page is that?
Page 108,
50.
the very bottom of page 108.
All fees and costs.
And this portion states, a local government may require a subdivider to pay or guarantee payment for part or all of the costs of extending capital facilities related to public health and safety, including but not limited to public roads, which this is a public road, sewer lines, water supply lines, and storm drains to a subdivision. The cost must reasonably reflect the expected impacts directly attributable to the subdivision. This is where we get into proportionate share. A local government may not require a subdivider to pay or guarantee payment for part or all of the costs of constructing or extending capital facilities relating to education. And then item number 2 states, all fees, costs, or other money paid by a subdivider under this section must be expended on the capital facilities for which the payments were required, which is what we do. We set aside these separate road funds.
Right.
So it doesn't just go into the general fund. It does
Right.
go into a specific fund.
Right. And I think this is exactly why Tara said, like, if you're extending capital facilities of say a road that's not done, that you can give them the whole bill for it.
Yeah, if they're the only ones out there,
Only
they
ones.
have to, they of course are getting 100%. Their proportionate share is all of it.
Right, you're
Because they're the only
extending,
one.
yeah, capital.
But we're not extending, we're improving the road. And we're looking at proportionate share. So, again, I'm not trying to make a legal interpretation on these items, I just wanted to,
No, I know there's something in there, but it just depends on whose interpretation you're taking. It's like John Flynn told us years ago, he said, he came down, we asked him a question, he actually came down to the meeting room and gave us an opinion. He said, of course, if there was another attorney, it'd be a different opinion.
Right, and it says may, not must. May.
exactly, yeah. So it's not a shall, it's not a, yeah.
No, and the first one, the governing body, for your local regulations, that those are the things that you put in your subdivision regulations.
Mm-hmm.
And my point is they're not in our subdivision regulation right now.
That section, and it said, it was on to say it must be expended. That's after you choke the money out.
Unless,
Expend it.
and I'm not trying to argue the case,
No,
unless
you know more than I
there
do.
is a specific reference to 76.3 and
Yeah, and there
these
may
two
be.
paragraphs. If there is a reference in there anywhere,
Then it would go
then
back
they
to this.
are
Okay,
in our standards, that's all. I can't tell you that they are or they aren't.
I can't tell you either. You would know better than I would.
But
We all were learning.
Yeah.
Even Herb and I have been here forever. We used to know Methuselah, but
yeah,
when he was on the board, right, Herb?
I thought we were getting booted off here about 3 months ago. I saw in the minutes of the meeting where they had made a resolution that they were going to limit terms on boards to 2 terms. And I said something to Darrell Folkford when I was in his office looking something else up. And Mike pipes up and he says, no, he said, you and Jenny aren't getting off that easy. Because we'd be up for immediate replacement.
Wouldn't we though?
Yes.
I mean, they couldn't get us out the door fast enough.
Well, I'm not quite a charter member like you are, so.
I would like to think you put up somewhat of a fight, Jenny.
Yes.
Okay.
The only way is if my jaw was broke.
Now, before we get too much further into the roads, can I ask you a question and then maybe we'll call a little miniature timeout? When I asked you about Dennis's letter, and I saw another letter back here on the agenda, I guess that's items for discussion because you have no new business. But what was your thought process on this?
So are we done with Antelope Run?
What do we decide on it?
To finish Antelope Run, I know Bernadette, I don't want you to be held
No,
hostage
I gotta
here.
run.
Yeah.
I think we decided that we're gonna leave it up to the subdivider to,
To
either he
decide.
can bring it, get new information, bring it back, or he can go directly
Yeah.
to the
Right.
commissioners, correct?
So do we need to make a motion on that, or we just all agree?
Well, that what I was getting out of Nicole, we didn't need anything in particular, but whatever you guys want to do. I mean, the idea being is that, yeah, it's got merit, but it's back in his court.
Yeah,
Agreed.
So do we need to make a motion, or?
I don't feel that you need to make a motion.
Okay.
I mean, you certainly can, but I don't feel the need to make a motion because you've not made a decision
there was no
necessarily.
decision, correct.
You've received information, you're basically saying, we understand and thank you. I mean, obviously more eloquently and, more
Yeah.
explanatory
No,
than that, but.
I think
Yeah.
that's an
No,
appropriate
that's-
place to leave it. I don't think there's any question amongst anybody in the room what the
Okay.
intent is.
I
It's
just
a
wanted to be
matter-
sure that we were done with
Okay.
that item.
Yeah,
I feel better about it, no matter what the decision is now. I feel like we've given everybody a chance.
Yep.
yeah.
Now, and I see a letter from Dennis and another one from another gentleman that expressing interest.
Yes, so what those are, Dennis's term had expired December 31st of 2020. So this is his letter stating that he would like to stay on the board.
Okay.
And I also have a letter in there from Richard Tramp, and I did not keep a copy for myself. But
Okay,
you
well,
each have
you
those.
can have one of these, but one reason before Bill gets out of here, because I know he's been trying to catch up to you,
Thanks, Dennis.
I would like, even if it can be like Dennis's, that you get a handwritten one from Bill if we haven't scared him off by now, because the beauty of the whole thing is that with Bill and this other gentleman, we're still maintaining an odd number, and we could have 7 members. And every time we get close to having a full board, something happens.
Yep.
1 to 3 people disappear for various reasons. So, the more the merrier. So, if you would make a point of accepting a letter from Bill, if he's still so inclined before you leave,
You're going to run out the door.
then the potential is that you can take all of these to the commission, and at some point in the future, we can have 7 members.
Are you Bill?
Yes,
Glad to meet you, Bill. I'm Jenny.
Jenny, nice to meet you.
Bill is my neighbor across the river, who I've been bending his ear for what, 2 or 3 months, and he was a smart man. He decided he wasn't going to answer one way or the other. He says, "I'll come to the meetings and see."
Across the river, what, over towards,
He's on this side. He's right across the road from Watson's.
oh, okay.
So this is where I would need a motion from the board. If your recommendation is to accept 3 letters of interest to serve on the board. So currently we have 5 members. We would be adding 2 more, so we'd be at 7. So just to keep in mind also, your number for a quorum would go up, which is, not significant.
By
but
1.
just by 1, yep, instead of 3.
But if we add 2, we ought to be able to get 1. So I can't make the motion, folks. Somebody's
Oh,
got to
I
make
make
it.
a motion that we accept these 3 letters and you take them to the commission.
Okay,
I second.
There's been a motion and a second. Any discussion?
Praise the
All
Lord.
in favor, signify by saying aye.
Aye.
Opposed? Okay.
and just a sidebar on that logistically, because I know that this design really was set up for the commissioners. What we'll most likely do is, this is what we do with some of our larger boards, is we set up a different table configuration down here and then just move the microphones down so that everyone can comfortably be seated at a longer table. So I'll just make a point to get over here early. I'll talk to maintenance is what I really mean.
I don't know what it costs to set up these Zoom recording things, but it sure would be nice if the commission had put one back in their old room, because we had a big enough table, we could have got everybody around it.
Yeah,
I
that was a
liked
nice
it down
table.
there too.
Oh, yeah.
Yeah.
Okay. Actually, a better setup and room for more public even
Yeah.
than what was here, but that's beside the point. Bite my tongue because I talked about spending county dollars. Okay. So we got that one, and now we can go back and continue to arm wrestle. Let me find,
Mary, I do not believe that I've given you the supplements yet.
No, you
Did I?
have not.
Okay, I have it right here. Does anybody else need a copy of the subdivision application supplements? I believe it was just Mary and Trinity that we did them, but
That was, well,
Application supplement,
the supplement packet,
oh no, I don't need any of that.
okay.
did you give some to Trinity?
No, I had them in my office. and,
Oh, okay.
We were emailing back and forth, but. So I just have his copy here for the next time I see him.
thank you.
You're welcome. And that's double-sided, you're okay with that? With
Yeah.
a double-sided copy?
So are we gonna next go through the road?
Yep. I was just looking to see if there was anything just to save some time. I'm looking at my notes that I had written in the book.
Are we gonna
So-
go through Richlands, or are we gonna go through our Broadwaters and make modifications to Broadwater?
What I envision as being the quickest thing, and I wanted,
I'm sorry, I can't give you.
because
No,
we
no,
need
no.
to get through Richlands like we talked before, get them out of the picture. When we get something back, it's gonna say Broadwater County on it, and then we can go through those if there's something in there that we want to massage.
You talked to the engineer, right?
The consultants, yeah.
And you had him write up what we had.
I
including-
gave him, I went through my notes page by page on what we've done on everything. And what I told him, I said, everything except the roads and that one on 5U on the well pads.
Okay. And then you
Because
had
we
him
said we-
take Broadwater's roads. and
Well,
put
I
them
told
in
him if he got to the rewrite
Okay.
before we got back to him with an official decision,
there. Okay.
just to replace it with Broadwaters. Because there's one or two things in here, I got way more deletions than anything.
Which page?
The whole thing starts on page 63.
63.
Roman numeral 5H, which they may or may not come back in with the same
I must have the wrong, wrote the wrong.
enumeration on them.
This is on roads.
Page 63 on Richland.
Oh, Richland. Ta-da. I'm on Broadwater.
That's okay.
Broadwater's like page 24. And that's the other thing, we have 24, 5, 6, and 7, other than our appendixes, the sum total of our road specs. And you can see what Richland has 10 or 12. Well, they've got more than that if you took into account all the stuff that we already deleted.
Nicole, you had said something about not wanting to call things impact fees and that you can't, and I could be wrong, you can't make the roads an impact fee type thing?
Correct.
Why is that?
In order to have impact fees, you have to have zoning. And we don't have zoning
Okay.
to elicit that impact
And it was a lot of paperwork to do it.
Yeah,
Get
I
it
don't
done.
want to do
I
zoning.
mean, when we seen it,
But,
we went to classes.
so what do you call the fire fee? Because usually an impact fee is a one-time fee that you pay when you subdivide land.
we call it a cash in lieu of water supply fee. So the developer could provide water in the form of a hydrant, a well,
Okay.
a live well, a live hydrant. Or they could pay $1,000 per lot is currently what the fire board is accepting. So it's a cash in lieu of water supply fee.
So when we do the roads, it's a one-time fee based on the formula that whatever we come up with, but we can't call, it's an actual impact fee, but we can't call it that.
We can't call it an impact fee, no.
But we can make them, maintain them. We still have to make them maintain the roads either in the subdivision or out. So they're still impacted even after they do the subdivision, taking care
Well,
of.
usually the subdivision, don't they have regulations or where certain
Homeowners
lots are,
association.
homeowners are responsible
Yes,
for taking care of the
And then they
road?
maintain the roads.
Okay.
Yeah, we certainly don't enforce them maintaining the roads. We'd like to see them maintain the roads, of course.
Mhm.
But, that's, once it's done, it's done. There's nothing for the county to come back and say, it's time for you to make these improvements to your road. Because once it's recorded, we have no authority to enter into any discussion with that.
So basically, the road is a one-time fee based on a calculation.
Yes,
Okay.
yeah, we can call it that.
Before we get started, would we all like a little sense of humor? Little sense of humor, Herb.
Okay.
I went back to 1868 road regs, and I found one really sweet, funny one. In 1873, public highways established, and this tells you the territory, we were a territory at that time. The comments, what they did in 1873, if you read them all, they're really, really, really neat. They authorized county commissioners to establish, change, or discontinue all roads and highways running through their respective counties upon petition of 10 interested freeholders and following appointment of viewers, goes on to the road. Authorized, established of a road district and appointment of a road supervisor. And here we go. All able-bodied men between 21 and 45 years required to work on the roads 2 to 4 days per year or else pay $3 a day.
That keeps it even.
That's how they maintain their roads. But reading all of these, and it tells you, like 1895, they established that the roads were to be 60 feet wide, driveways 20. Anyway, these all back from seminars, some the regs all through the years, which is
Were those from Montana or were those?
yeah, the Montana.
Okay, well, the reason I was asking, because you were talking about something prior to statehood, I was just curious.
Oh,
if
yeah, and also, in order in 1895, what they did, they established at the time, like if you get the BLM maps and everything on them, any road that's been traveled, any road, traveled at all, one person or a bunch, is considered a county road at the time, because they didn't have any time to have the money and all for a surveyor to go out and survey all the roads, so they just said any road established at this point, which is still to this day, we've had roads that you didn't even know was a road. Like,
No.
I'd
That
always
was an
liked
issue
to,
out of Radersburg. See,
Yeah.
that was one of the earlier
right,
mining towns, and there was roads there that are
right. And
through use.
when you used to say Radersburg, everybody used to quiver. Toston was one of the best towns ever surveyed and neat.
Yeah, that was after the rail.
And the Radersburg was a different story.
Yeah, that was a mining town.
it'd be interesting to see what an attorney would do with it. I followed a 2-track that was perfect. There wasn't any question about it. It was a 2-track made by a vehicle. And then all of a sudden the cow path merged because they weren't walking side by side. They were walking single file, and one of the 2 tracks disappeared.
Went to a 1-track.
Oh, well.
But anyway, that's my little bit of sense of humor. But if you ever want to read any, they're fun to read.
Where did you find them?
I went to class.
Oh,
You used to, in the old days, have to go to school for roads. That must be pre-stroke. My mind's not. as
Jenny
correct.
has a PhD in research that has about 4 layers above PhD on it, as far as I'm concerned.
Used to be, not anymore.
If you want to know something that's happened, she's come into meetings and pulled something up out of her files and said, no, in such and such a year, the commission said this. And they go, wow. So that's why she gets a PhD. Okay, let's get back to the roads. Having said that, but doesn't make a whole lot of, one of the least things that I had any problem with is the very first paragraph. It's just descriptive. It's a bit wordy. It talks about how they will be designed. I really can't think of, I guess the only thing that would enter into it on our standards, because we have the Montana Public Works, we refer to ASHTO, would be the stuff about MDT and the geometric design. But all it is a stipulation of what standards things have to be designed to. There always has to be some kind of a standard, because then you wind up with, like what Jenny was
Agreed.
just reading, there's, you know, somebody thinks that, yeah, this is a 2-track until the cows walk single file. So that gets rid of the single file road. That's my only point about it.
so did you want to eliminate the,
No, I don't see a problem with that one.
okay,
Probably the easiest thing in my mind, we'll see what everybody thinks, but essentially, we could go all the way, well, let me get back here. I think one of the first things we did at one of our very first meetings was get rid of all these pretty pictures. But effectively, with some minor things from page 63 of Richland through page 77 of Richland, we would substitute the existing Broadwater County roads. And if anybody else jump in here, it's just that I've read these so many times because we kept scheduling meetings and getting them postponed, and my memory's not good, so I had to reread them.
All right, yep.
So every time I'd find something different.
well, 74, 75, 76, and 77 are just pictures.
Yeah, but all of that
Take
is
it out.
good. There's no pictures in ours, because what that does, when you get, there's a couple of items in here that we'll go through on a page basis. Where did I get to? That I referred to. Ours, we only have 4 pages of written word, like the table that's on page 73. That's in, this is Richland, it says 5-1 roadway design standards. I scratched the whole thing out and I said replace with tab A1, page 108 of Broadwater County standards. Because there's things in here that aren't the same, they aren't realistic, they've got flatter grades, but Richland County is about like this tabletop. There's not very much of this. So none of that fit, in my opinion, so that's one of the inclusions that as we wiped out those 14 pages,
Okay, so we wiped out 64, 65. Because I got a lot that we did, I don't even want to go through it, but
yeah, well, that's my reason for saying that, and then I think the easier thing to do, Jenny, is to come back and look at everybody's comments to see if there's anything good. There's one thing on secondary or emergency access that I think somehow needs to find its way into our specs because we've run across it before in terms of having too narrow a right-of-way. But that's not,
Emergency road, you mean?
What page
Yeah.
is that at?
Hmm?
That emergency access you're referring to?
yeah, what I was talking about is on page 65B. My comments there, and this is only for major, it says second access may be required, not is required. And then you drop down to the fourth line at the end, it says, they're talking about the exception of the road width, it says, which may be 18 feet and easement width which may be 40 feet. I personally have a problem with 40 foot because think about Rousers. All they had was a 40-foot easement across and they wanted to put a subdivision right next to them. That was the objection that I had. Everybody else voted for it, but not because of my objection, but because of I don't even know if it was the 40 foot. It's just we shouldn't be building something in like this to our standards so that 20 or 30 years from now, if it becomes a road, it has only a 40-foot easement. If there's going to be an access, then it needs to be a 60-foot easement.
60 foot.
Because that takes care of what's there. River Road's a good example. About half of River Road south of my house doesn't have an easement. It has a prescriptive easement, but there are no dedicated recorded easements.
I
From
just had
Dennis's
a-
driveway south, there's only half a road.
Right.
Can't hardly pass.
So it doesn't make sense to me, and I'm not saying we need to have it in, but if we're gonna have it in, any place we have an easement, in my mind, needs to be 60
60
feet,
feet, standard.
for whatever reason. That just eliminates the problems.
Not built or anything, just that there's an easement on that plat in case they should need it.
Yeah, 40, 50 years from now, gets all built up and they want to turn that into a road, now they have the legal right to do so because it's wide enough for the road.
I looked up half roads too.
I'm sorry, I couldn't hear you.
I looked up half roads, and it says in a lot of the books and ours too, that you may have a half road, and in some places they require them.
Mhm.
So like we did at the south of the county, so that the subdivision next to it built. I think Fritchie's, wasn't Fritchie's have some half road or something? Down by the golf course. But anyway.
What kind of road is this? I don't,
A half road.
A half road is a center line, one direction. The
Okay.
other half isn't
Down the other
required.
field.
There's one down at the south end of the county that's in Jefferson County. So obviously you can't
pass, or,
tell somebody in this county, they want to subdivide, you can't tell them you gotta put the easements there, but you can't say you gotta build something in Jefferson County. There are places that I have run across where it was required, but it was because it went back to the monetary issue. They wanted a subdivider to pay for their half of the road. But it wasn't just a graded road. I mean, these were literally half roads paved all the way up to center line, and then you had to,
And then
Take
if the
it from
person
there.
next door subdivides, they put the other half on, and then the reasoning for it is if you have a subdivision here and a subdivision here, and you're coming up here, you don't have to go back out on the highway to come around to this subdivision to visit Aunt Mary. And so that's the reason for half roads. It's looking ahead.
what if you have subdivision in 2 counties? Or a road that's going in 2 counties?
Oh, they do.
Oh, do they?
Jefferson and Broadwater. What they used to
Price
do.
Road
in-
winds up in Jefferson County.
Grassy Mountain subdivision is in 2 counties. Are you familiar with Grassy Mountain subdivision? On
It's
the way to White Sulphur?
yeah, yeah.
Yeah, we have half of it in our county, and then the majority of it actually is in Marr County. So it just goes through 2 reviews, and whichever county the property lies in, that plat is recorded in that county.
Gotcha.
Okay, that was my only point about that was just coming back. Is everybody in agreement in general, not only from expedition? I have no reason for not wanting to go through it page by page. I just don't want to waste time. That 63 to 77 we replace with a few comments added to Broadwater County existing subdivision standards.
Yep.
Okay.
I agree.
Okay. Oh,
Boy, this is happy.
now, these are just some things, I mean, granted, we've deleted them, but there's a couple of things that I picked up on that we ought to discuss, at least in my opinion. On page 64, they're talking about roads in relation to adjoining lands. Developing subdivisions shall provide, that could be may, could be anything, access and utility easements to adjoining lands when access to those lands must pass through the subdivision. The developer may be required to provide legal rights-of-way easements, and the access must be constructed, and so on and so forth. I've got a big question mark there. What do you do with state lands? If you got a state section, most townships have, in Montana, have 2
16 and 32 in
Yeah.
all counties.
state sections. That's public school money and so, but it's also hunting and everything else. I'm not really sure what they have in Richland County, but like I say, it's already been, I'm not proposing that we add anything back because we already deleted it, but it's something that we need to think about in the final review as to whether or not we need to address access beyond the subdivision. Like say if it butts up against BLM, state ground, Forest Service, et cetera, et cetera.
We have some out off of White Horse Road, don't we, Nicole? When you go up White Horse Road, if you go on up, you're into government land. Yeah.
Yeah, White Horse is not a county road.
Yep.
So we would give them access, the
Well-
public access to the BLM? Is that what you're saying?
I'm saying we need to think about our final version
Okay.
in terms of how we do it, because I can't think of an example right now.
Okay.
But the one thing that I like about ours is general enough that it kind of covers the situation, because essentially if you had a whole series of subdivisions up against Forest Service, BLM, you're not going to have it against state because that's only a mile. You could be deemed to be denying access to public ground.
How can you be denying when nobody had access to that before?
They've had access to it if there's not a subdivision there.
Well, it's private
Well,
land.
what I'm getting at is you're dealing with 1, 2, 3 property owners. I'm not talking about next year.
Okay,
I'm talking about 20, 30 years down the road, that it merits consideration how that would be addressed. That's all I'm saying. I'm not saying we need to put it in there, but it needs to be in the back of everybody's mind that it could be a potential problem. That's why I hesitate to go back on anything. I'm not trying to slow us down. I was trying to,
no, it's good.
just
It's
food
good
for
to
thought.
know.
Well, the other thing, essentially the same thing, and you were talking about it before there, Mary. Over on page 67, in there's 4th line down, they talk about establishing a property owner association or a road user agreement. The county doesn't have anything to do with property owner association or anything else. In my mind, we would be more appropriate to require a road maintenance agreement and stay completely out. We're already out of it by choice, but I don't see why we'd even want to put it, list property owners association in there in regards to roads.
So are you saying in the, not in the regulations?
I'm not even sure what it says on ours right now. I'm just saying that's my personal opinion, is that because we don't do anything with road owners, I think we have it in ours, don't we, Nicole?
I don't know, I would have to look. This version on my phone is very, very small. It really
But
is.
that,
Another reason why I enjoyed that basement meeting room.
I'm just talking about the final version.
Right,
Food,
right.
food for thought. I'd much rather get through all of this and be done with it.
Property owner.
Maybe that could be a covenant that the county requires in the covenants, that all property owners in a subdivision are required to maintain the road.
We found out it's come down at times, and I don't like to judge one person and affecting all the others, but we have no way of making them pay into the roads, the homeowners association. We have no
Right,
way.
right. You still won't, I mean,
Right,
Yeah, there's no teeth in it, so,
Right.
I don't know if we could design it so there's teeth in it.
Josh,
you're right.
Josh Obert and I have been working, as well as the commissioners, we actually had a training session to discuss RIDs. RID stands for Rural Improvement District, sometimes been referred to as a road improvement district. But we are making plans moving forward to start implementing RIDs within subdivisions. But we're not there yet, but that has been a topic of discussion that we've had for ongoing maintenance in subdivisions, that they would be a part of an RID. It's just a bigger animal than him or I want to take on right now, or have the time to take on in our departments, but we have
well,
good
you
communication with
don't,
commissioners.
I would suggest that all parties talk to Jerry. I found out when I met with him last week, I didn't realize, I knew he had worked for the state in the past. He also worked for Lewis and Clark County. He said has varied between 4 and 7 county employees doing nothing more than taking care of the RIDs, because that money, when it comes in, has to be accounted for. Now then you've got these county employees that are actually doling out those funds to whoever the contractor is that's doing the roads.
Yes, in fact, it was Jerry and Phil, I can't recall his last name, also works at Great West Engineering, that presented some information and gave the 3 commissioners and myself and Josh Obert a 2-hour lesson, a 3-hour lesson, in fact, on RIDs. And he did say that Lewis and Clark County currently has a staff of 3. So that's how we know that we don't want to take it on
Yeah,
in
no,
either of our departments right now, but it has been an ongoing discussion. So, we're hoping to have something implemented within the next few years.
Well, my personal opinion, it's something that needs to be addressed at the legislature and how they would handle it. They need to give all counties an idea of a reasonable way to do it. Okay, the one thing we just deleted, and I didn't look to see if it's in the same thing, is rural addressing in unincorporated areas. What does our spec say? Do we want to put that one paragraph back in, Nicole?
I saw that, and I don't think it's necessary to put that paragraph back in, because that is a commission-required covenant. It's also required if you want power. It's also required if you want a septic permit. That you have to obtain a.
So
an
they have
address.
to get an address before they can even put in for those,
Mhm.
Mhm.
okay.
Yeah, so I don't know that it's necessary to put in the regulations because it's typically not the developer, unless they're doing a spec home, that would be applying for the address anyway. It's.
Well, the other part that I had it underlined in here, they're talking about a building permit process. So they're not it's not like going in and paying your driveway fee. Because you don't charge them anything other than the cost of their numbers, do you?
Yeah, it's a $20 fee for the
No,
address,
okay,
yeah,
but
which really just covers the cost.
to me, when you start talking about a building permit, you got a lot of zeros behind it. 3 or more. But
Nicole, how's the county budget for roads?
County roads?
Mhm.
That would be a better question for Josh, the Public Works Director, or the Commissioners. And they're building their budget when Josh is building his budget. I don't know what, how he pulls those numbers in.
Because it just seems like if you're gonna charge money for a developer to add to a county road, then when the developer develops those houses, you would think that a percentage of those annual taxes go into a road fund or something that pays for that. So is that calculated on how this road gets maintained and stuff? Or does it all just go into a pot and whoever screams the loudest
That's an
Yes.
excellent
gets
point,
the pot?
That's a good question.
yes.
Okay.
Yeah.
I mean,
Yeah, no, so I do know that if you live in a development, a subdivision development, I saw that after you
It's
left,
nice
yeah.
when you forget your code.
That is nice. So the residents of this subdivision development, if they're accessing off of ABC County Road, those funds don't just go towards that county road, they go for the whole county. So even city residents, on our taxes, we are assessed county road fees. So everybody pays into the county road fund. Because in theory, everyone can drive those roads. So not just because you live on that development are your county road taxes going directly towards that road.
When Virginia Knurr was here, in the room Herb likes down there used to be jars. And it had pennies in it, according to where our county taxes went to. Like 50 cents went to roads and 25 cents went to schools. She had it in there, so you could go down there. It was really unique to see. I mean, it made you visualize where money was actually going. I don't know what happened to those jars.
They probably spent the money.
Probably needed it for office supplies.
yeah, I found an old-fashioned bubble gum machine and started.
Well, it just seems odd that if the developer is paying a fee, putting money aside to develop that road, for lack of a better term, impact fees, because you're not using impact fees, then the people that build houses in that subdivision, their money doesn't go to supposedly fixing that road. Could just, that money could like go into a pot and never get used. And it just seems like, it doesn't seem like and maybe there is someplace, a strategy for how this money in these roads are. I mean, we've spent a lot of time, and you guys have since I've been here, talking nothing more than how do we fix roads and who pays for them or whatever.
Well, in theory, if I understand your question right, it's supposed to go into a separate fund, but in practicality, I would say that it's seldom used, and I am unaware of a master plan that says we're gonna fix the 2nd to 4th mile of Ray Creek this year. Nobody has that kind of
And amen.
Master plan.
That was my question. It's,
Yeah.
there's some money out there someplace, nobody knows how much it is, where it is, and if somebody screams loud enough, this developer is gonna get some of that money to fix their road.
You know, there's all sorts of room for improvement on that subject. I'll leave it at that because we could be here all night
That's why we left the
otherwise.
roads to the end, because they're a mess.
There needs to be a master plan and some device so that it is equitable. And just like Mary's question about what do you do if you got a subdivision in different counties, to me, the right thing to do would be for the legislature to come back and put something in here that stipulates what you're gonna do with it. That you have X number of years, once it reaches such and such fund, or the county has to match it with reserve funds, or there has to be a plan so that that gets done.
So that gentleman, that's this subdivision we talked about earlier, if he would have yelled loud enough and they would have fixed that KOA road, it wouldn't cost him as much now.
I don't think that that's necessarily true. You know, the county road supervisor, Josh, Public Works Director, he puts together a list of priority roads for the county. Typically, those are school bus routes or major arterials. And so at the beginning of every year, and every road department manager has done this, as far as I know, they put together their list of priority roads. So at the beginning of every year, they have their list of priority roads. They also have their list of roads that they plan to fix, you know, and the schedule, and I shouldn't say fix, that's a pretty ignorant term, but
Improve.
to improve. So, you know, they put together their schedule based on the amount of money they have available to them. So it's not always just who yells the loudest, or,
Okay.
you know, there really has to be some justification for why this road is getting the improvement as opposed to this road.
And
Yeah.
politics may play a teeny-weeny part in decisions made about which roads get taken care of.
I agree.
First, second, third, fourth.
Agreed.
Because I've lived on some of those roads for 60 years, I've seen quite a change depending on the political stance of the people we've had making the decisions.
And a little addition to that is that the way the law reads, the county doesn't have to do, and KOA would be a prime example. There's one individual beyond this subdivision.
Okay.
I don't know what his capabilities are, but I would venture to say that he has been maintaining.
He's the only one on that.
Because he has a 3-yard loader sitting in his front yard. I would suspect that he was taking care of his access to his property over KOA Road. And because when I went up to look at it, there was remnants of it having been plowed, and it hadn't been plowed by a grader, let's put it that way.
Well, a good example was the Raidersburg Road. It was gravel forever until a gentleman by the name of George Pennell got put in as commissioner. And 2 years later, the Raidersburg Road was paved. And this was in 1946 or 7. It's been a while.
A little while.
But, you know, just human nature, it makes a
Right.
difference on
Yeah.
how the politics of the area work.
Okay, in the name of progress, let's jump ahead to that one on, I only have 2 minor things, and again, they're kind of like stuff that we would add back after the fact on the roads, so that we can say that we're actually done with the book, and Jerry can start printing.
Work his magic.
And what page are we headed to?
Oh, somewhere here, I think I was smart enough to write down the page.
We were done.
B
something.
sub U must be, once upon a time, I thought I had a little sticky on it, but it must have come off. Oh, there it is, I dog-eared the page. Page 86.
needs.
This is one that we decided to revisit, just skip over. It doesn't particularly fit our county. I don't even know if we want to go into it, but the way this thing is set up, my only thought about it is that it at least addresses a potential problem, because there's areas everywhere in the state, not just in our county, where the property owner only owns the surface rights. So if they were to subdivide, it's not because I think that we're going to have fracking and that sort of thing, but I think even though it doesn't fit, I first was going to throw it out, but I'm not so certain that it might not do to just leave it in, because they even have a picture. They talk about it as a wellhead and equipment, but you could do that on definition or whatever, but it's outlining how much of a free zone, clear zone you need to have around that type of thing. One other thing in here is down at the bottom of the page. It says well and facility pads cannot be within areas dedicated as parkland. Because if somebody was going to subdivide that area and there was already an existing one there, that's saying, no, you can't dedicate that as parkland because now you have an industrial park. Because you've got a jackleg sitting there going around and around. What does everybody else think about it? I don't see it fitting now. I just see it being a precaution. It'll seem out of place, but it's not necessarily a bad thing, I guess is.
Yeah.
I have one thing. Are you talking French or German? I do not understand any of this wellhead, connecting pipe, equipment. I do not know what it even is.
What they're talking about is like an oil well,
Okay?
a fracking well, something where if large companies go around and buy up mineral rights. It's just like the stuff you see in the newspaper all the time, where companies they'll go pay tens of thousands of dollars for permits, for drilling permits on Forest Service ground. That's always a political deal if it's on government ground or whatever. Probably don't have the intent of drilling on more than 2 or 3% of that ground ever. They can make so much money that it's kind of like money in the bank for them, because now they have a place to go.
So they have a place to go. So what does that mean now? Nobody can do anything with that piece of property, or?
It's limited as to what you can do
Limited
with the
what?
property.
Well,
You could have a driveway across it, or you could build a house over there.
that's one of the things that isn't addressed in there, but to put it in perspective, I don't remember how many years ago was it, Dennis? It's only been 2 or 3 when they wanted to frack under the town of Baker,
Yeah.
because the whole town didn't own the mineral rights under the town.
That's cold strip too. They don't own any.
But the idea being is they banded together, but because of all of this oil stuff, because with the Conservation District and MACD, we have knowledge of what's taken place in the eastern part of the state, and they actually it's a private organization, but it's almost like, for lack of a better term, I'll call it a subscription attorney.
Okay.
They have a land use attorney, this group, and these are just ranchers and farmers in the eastern part of the state. You've got lots and lots of ground. They need it to make their livelihood, but they don't own the mineral rights underneath.
Gotcha.
So they banded together, and it has actually worked well, because even the oil companies like the idea that they're only dealing with one person. Because if they're part of this association or group and they want to drill somewhere, they call this land use attorney someplace, I think he's around Casper or somewhere down, I know he's out of Wyoming. But they have a set of rules and whatnot. All I'm saying, no, it doesn't fit now, but I don't see that it hurts anything, and maybe it will keep future generations aware of the fact that you better be aware that this kind of thing can happen.
Yeah, probably, I don't know how many people know, but they drilled a gas well out the other side of Raidersburg not too many years ago. And they got down, I don't know, 3,000-4,000 feet, and they stuck the drill head and had to twist it off, and they didn't want to put all that money into re-drilling it, so they pulled off. That pad's still up there, and they felt, the company at that time felt that if they got down, I don't know, they had about another 2,000 feet to go. There's a tremendous amount of natural gas under that area. And they come in with helicopters and tested all of Crook Creek Valley from the air with instrumentation. And then they drilled up there. Little Bill Williams owned the property the other side of Lone Mountain. And so there's a potential for gas well drilling right behind us. Yeah, so that, you know, I think this is important for these little kids
Like I say,
running around to.
In my personal
able to keep
opinion,
it clean.
we've talked about it too long already. My only feeling is that it's not a bad thing. It doesn't apply.
Yeah.
But, yeah, that's right, that's key to it, is yet. But at least there's some groundwork to build on if that sort of thing rears its head. And you can almost take it to the bank that it will sometime in the future, because not all of the property in Montana owns the mineral rights.
I'm fine with it being in there, I just would like to understand what the regulations are as far as if there's mining or gas wells or oil wells, what the restrictions are as far as the regulations, because I don't quite understand.
Well, I think we're, you know, if everybody agrees that it probably ought to be in there, then that needs to be you
Discuss later.
flag the book, and we need to figure out what each one of us thinks ought to be in there when we go through the book that we're gonna get from Jerry.
Okay. I'm good with that.
And,
I would really, I'm with Mary, I would like to know what it even is. I can
Yeah.
see this and putting it in as a safety feature, but I would like to know what I'm putting in there.
yeah, and I'm not even saying the dimensions are right, it's just the concept that I'm talking about.
Yeah, I guess I don't understand, if you don't have mineral rights, what's the regulation? Or if you have a oil well in your land, can you subdivide, or, I don't know, I don't understand where.
Well,
what the-
part of it could be as if, like that one paragraph that it says about the parkland, that would, to me, that would be an existing well. If somebody
You couldn't
owned
put a
the
park.
surface rights around it and wanted to subdivide it, they couldn't say that the wellhead was the
Okay.
parkland, because they're specifying an open area around it. It's the limitation between the fact that the landowner would be or should be anyway compensated by the leaseholder, whoever's doing the drilling. I shouldn't even say that. Whoever owns the lease will have to negotiate with the property owner both for the amount of material, the amount of area that they're gonna have, and what compensation they're gonna have.
Okay.
All this is saying is that if there's one pre-existing, you can't
Use it
put a
as-
park there, you can't, you have to have some kind of buffer, it has to be fenced to keep the kitties and the dogs out, and so
Gotcha.
on and so forth. like I say, it's not applicable now, but it's not a bad thing either.
No, I don't think it's a bad thing to have something in there, just so it's understandable and
That's the
makes
word,
sense.
understandable.
Because I don't understand what they're saying.
Well,
There is
Jerry'd
one-
be a whole lot better one to describe it than me. I know what he's talking about, but I think he has some firsthand knowledge through the company and or the state, because he used to work for the Department of Commerce. So can we declare that we are done with,
Yes, but I have a question. So we've talked an awful lot today about roads. What, and maybe you talked about this at your last meeting that I was not here for. What's the plan for the regulations for roads, for proportionate share of improvements? Are we putting anything in here, or are we not putting something in here? I thought the original discussion was that the planning board wanted to.
we talked
recommend-
about that at the very first meeting, that to at least put it in the first run was the Lewis and Clark formula.
Okay,
And that's what I told Jerry. I said, you
Okay.
find the appropriate place to put it in, because we're all gonna look at this again and go through it. If he thinks it fits in roads, if he thinks it fits someplace else, that's why the county's paying him, or his firm, to do it.
And we can discuss the formula afterwards?
Oh, yeah, this is only the first, all we're doing today, as far as I'm concerned, is getting rid of the Richland book.
Okay,
We're gonna get a book back like this from Great Western Engineering, from Jerry Gabens, and it's gonna say Broadwater County on it, and it's gonna have all the changes that we've made,
okay, and then we'll go through that.
and then we'll go through that and decide what we're gonna do, you know, what's the final.
So it's
But-
all coming back in a Lewis and Clark format, so to speak? and not-
No, just for the formula.
Just the formula.
formula, okay.
There's like 3 pages there or something of that nature.
Okay, because this is my Lewis and Clark book. It's a mess.
Also, I want to clarify, the county is not paying Jerry Gerbens. This is being paid for through a grant from Community Development Block Grant Funds. I do have a key. Thank you.
Well, the county's paying for him with grant that they applied for.
Right.
Understood?
Any other comments, questions? You know, we can get into it in the future, but does anybody have a burning desire to add something from one of the other ones that Jerry gave us? Madison, Carbon, Lewis and Clark, Gallatin.
I did Lewis and
I didn't
Clark.
see anything in any of those except that formula from Lewis and Clark that I thought warranted.
I can't comment on that because I didn't have Lewis and Clark's or any of those other ones.
I think
Okay.
all we got from Lewis and Clark was the, and did I give you this? I have a note on here for Mary Heidemann to pick up, but I think I gave you the general design and improvement standards.
I think
Because I
so.
think I had several copies of it. Lewis and Clark County subdivision regulations.
Yeah, maybe
Yeah.
I
Okay,
did get
okay.
that.
So I believe that that's what Herb is referring to.
Yeah,
I
there-
don't know that this board actually had the entire copy of the Lewis and Clark
Yeah.
County subdivision regulations.
Yeah, there's
Just
about
the
3
design.
pages in that Lewis and Clark excerpt that has the road formula in it
Okay.
and how it applies.
I think it's a good idea just to get our first draft done and then we can actually go through and,
Well, that's it. I mean, it's try to make sure, there's probably an extension coming on this grant, but we don't know that for certain, so let's get everything we can out of it.
gotcha. I think
And
that's a
then,
great
and then we
idea.
go from there. And then I would make a suggestion before we adjourn, because we didn't do it the last time, but barring any particular things where you have a new subdivision coming in that you're under a deadline for, I think we should set a meeting date for April, because that's one of the months that we're required to meet. And I would be in favor of putting it towards the end of the month.
I'm gonna be out of town in the middle, like from the 6th to the 12th. So,
Yeah, I don't even remember if I wrote down a date, but I was thinking like something in the 20s.
yeah, I'm good with that.
Because in the state says we have to meet in January, April,
July.
July,
And
and
October.
October.
Okay.
So we could either do Wednesday, April 21st, or Wednesday, April 28th.
I'm good with either.
Please not do Wednesday.
Why don't we do the 21st, just because I can remember that number a little better?
We can do a different day
Day
than
of the
Wednesday.
week.
Yeah, I mean,
Jenny
it-
is
Yeah.
requesting a different day than Wednesday, so
Right.
you need to establish what day of the week you would prefer to move these
Any other
meetings
day,
to.
I'm fine.
That part of it doesn't enter into it for me, for the
No,
most part.
but it-
It's
whenever
more
it's
about
done.
your schedule, Nicole, in terms of what prior commitments you have on your time.
Right.
So Mondays do not work. We could do Tuesday or Thursday. That would be preferential to me.
Yeah, either day'd be fine with
Either
me.
day is
Makes
fine
no
with me.
difference.
Makes no difference.
Do you want to go, I guess I really, I have no preference. Thursday would be good because
Thursday's good.
sometimes Tuesday is trying to
Right.
catch up from Commissioner Day.
All right, Thursday.
Thursdays, okay.
Okay, that works. I got no problem with it.
Yep.
Thursday, what is the date?
The 22nd.
22nd? Okay. Got it.
So I have one quick question. In 1 minute or less, before I give her my letter, what actually is the role of this board?
Advisory specifically,
So.
you can sum it up with that, what did I say it was? It's in here, but it talks about the role of the planning board for subdivisions.
So you don't. really
It's
take it-
strange in my mind that the commissioners are not supposed to know anything about the subdivisions before they have to pass judgment on it, and they get staff decisions. So the way I look at, effectively, we're supposed to be their eyes and ears, I take it. They don't want to have to sit through these meetings, so we have to, and then we make a recommendation, and in a matter of 10 or 15 minutes, they decide what they're gonna do.
So are you supposed to take into account expenses and cost? Is it gonna cost the money, or county money, and how stuff gets paid for? Or do you just look at a subdivision going in and it says, yeah, that looks like a good subdivision, and
Just coming in.
It's not about whether or not it's good, it's about whether or not it meets all the criteria of the law,
okay,
the standards and/or MCA.
okay. all right.
If it meets that, there is little or nothing we can do to stop it.
Okay.
All we can do is try to minimize the impact, make sure they follow the law.
All right, next meeting,
coach, you should take that.
the 22nd at 3 PM in this room. If there's another board that's already meeting that Thursday, we may have to switch to a Tuesday, but, so just kind of keep that in the back of your mind. We've
Or
tried
we
to
could slide it
establish
back
this.
a week if it's not something, as long as we meet in April, that was my only
Well,
point.
we would still have another week. I just mean as far as boards with established meeting dates. We, as a planning board, consistently have been meeting on Wednesdays, so other boards have set their times to meet around ours, if that makes sense.
Mhm.
And likewise, but I don't know off the top of my head what other boards are meeting during the day or the afternoon, so.
Well, just send an email
Yeah.
and let us know.
Okay, motion to adjourn?
I'll make a motion that we adjourn.
Got a motion, do we have a second?
Second it.
All in favor?
I
Opposed? We're adjourned.
The reason,
You made it in 2 hours and 3 minutes.
Bernadette, she teaches RE, religious education, every Wednesday. And I'm
Bill,
supposed to be
there's a
teaching
paragraph that
volleyball.
explains everything.
Oh.
So.
The one that's highlighted?
I have a million
The-
kids, 5 pizzas I usually eat.
This one right here, paragraph
And now
one.
Can I take this and read it, then I'll-
regs,
Sure.
Get it back to you.
know,